given this last child support letter, they did not take me to court, and you guys made a judgment against me. That's fair. I didn't. I'm here trying to see if I can see my children, and you guys just want money out of me.
Okay.
I'm confused here.
Mr. Welch.
Enjoy the video. Hit the like button.
Okay, you put your hands down. And ma'am, if you'd state your name for the record, please.
Ignacia Vargas.
And sir, if you state your name.
Andrew Welch.
And if the attorney would please say his name and who you are.
Cody Morgan for the Office of the Attorney General, Child Support Division.
Okay, Mr. Morgan, why are we here?
Judge, we're here on a modification case. This is a case where we're modifying because Mr. Welch, the non-custodial father in this case, got released from incarceration. So we'll be wanting to do a temporary order today, ordering Mr. Welch into the NCP Choices program and establishing a minimum wage presumption order in this case on a temporary basis. The testimonial evidence will show that there are 3 children inside the case, 1 child outside of the case, which makes our child support $310, and medical support for the state will be $30, Judge.
Okay.
And I believe I pulled up the pay record. I just remembered about that. Let me see. Yes, and the state will be taking a judgment today for what Mr. Welch owed in both child medical and dental support arrears.
Okay.
And he only has arrears, if you're ready for it, in medical support, which is $730.08 as of January 31st, 2026.
Wait, he owes $730.08 in child support arrears?
In medical support arrears.
$730.08 in medical arrears?
I have a question about that. My job had an order to withhold. If my job did not do that, who does that fall on? I gave them my order to withhold. They were taking it out, and then I found out that he wasn't taking it out of my paychecks.
Right. And Mr. Welch, what happens is, and a lot of people are confused about that. They think that, well, I got a withholding order and it's not my fault that the money wasn't paid. Actually,
my job received one. He was taking it out, and then for some reason he just stopped. I don't know why. But he had an order from y'all.
No, I understand. What I'm trying to explain to you is that you still have the obligation to make it right. Now you can go to the job and say, hey, y'all took the money, you owe me this money, because I had to go and pay it, because the fact is Ms. Vargas has not received it through no fault of Ms. Vargas. And I'm not punishing you. I'm just trying to tell you that a lot of times a person will be ordered to pay child support, and it's supposed to be a withholding order. And so they don't pay for several months until the withholding order kicks in. And then they don't understand why they're deemed to be behind. And it's because the obligation is the obligation. If you have issues with them taking it out of your check or doing what they're supposed to do, then that's between you and the employer. And I appreciate you letting us know what happened.
Yes, I'm just trying to figure out what I can do to make sure they pay like they were supposed to. Like they were taking it out, and it was being dispersed, and for some reason the old man just stopped. He just
right. And when he stopped, then it wasn't taken care of. I understand. So I'm just letting you know that. Are you know that was that employer? Is that the employer you're with now?
No, sir. I don't work there anymore because he was
right
in general. Yes, sir.
Right. Okay. You may proceed, Mr. Morgan.
Thank you, Judge. And just for the court's awareness and everybody's awareness, those medical support arrears are owed to the state. And so the state has an interest in taking a judgment on that. With that being said, the parties are in agreement to, again, making this a temporary order. And I think I already laid all of that out, Judge. So if I am ready, I'll proceed with questioning the witnesses.
Go ahead.
State calls Andrew Welch. Mr. Welch, could you please state your name for the record?
Andrew Welch.
And, sir, your relationship to the 3 children in the case.
I'm their father.
And, sir, you heard me read a moment ago into the record what I believe to be the agreements in this case. Did you hear that?
I have no problems paying to see my children as long as I get to see my children. That's my issue. I'll pay. That's the only thing.
And sir, you understood that the court has made prior orders in regards to possession and access, and the only thing before us today is setting support.
So you guys are going to try to tell me I have to pay money, because if this is the best interest of the children, I think me being in their lives would be in the best interest. So the line here, I'm being very courteous and professional about this. It's I did not tell you this was going to happen. They were going to tell me this.
Mr. Welch, can you hear me okay?
And
You keep freezing up.
why can I not see my children? I received an order from y'all when I was in Victoria County Jail, and your deputies there did not take me to court, and y'all made judgment against me. I was in the state's care. They denied me my court case, and I'm being punished now by the state because of something they refused to do. I can prove all this. I was incarcerated in Victoria County when I was given this last child support letter. They did not take me to court, and you guys made a judgment against me. That's fair. I'm here trying to see if I can see my children, and you guys just want money out of me.
Okay.
I'm confused here.
Mr. Welch, are you going to wait?
Yes, sir.
Will you let me speak without interrupting me? Okay. Just I've waited for you. Now I'm going to respond, but I got to tell you, we apparently are having some technical difficulties because you keep freezing and then unfreezing. And Ms. Vargas, you're now muted, so you need to unmute yourself. But Mr. Welch, let me address what you just pointed out. Supposedly, Mr. Morgan has worked out an agreement between you and Ms. Vargas with regards to the child support. Okay, supposedly. And when he started to talk about that, you brought up, I just want to see my kids. I'll pay support if I can see my kids. Okay, when you said that, here's what I'm trying to do I'm trying to actually help you here so you understand. And when he said, well, that's not before the court at this time, that's when you got, seems to me you got a little angry and was like, well, y'all just want this money and you're not going to help me see my kids. Okay, let me explain to you why the statement was made by Mr. Morgan. Okay? The orders always say, all the court orders will always say, it's standard for us to put this in. It's in bold print, and it says, failure to get visitation is not grounds for failure to pay child support. It also says failure to get child support is not grounds for failure to allow visitation. So what I'm telling you is that you have a right to have an attorney help you with the visitation issues. That's your remedy. You can file stuff and be treated very, very fairly by the courts with regards to seeing your children. But it has to be the issue that's before the court at that time. So, for example, if you hired an attorney and you filed because you weren't getting to see your kids and y'all went to court and Ms. Vargas was to say something like, well, I don't let him see the kids because he doesn't pay child support, then Ms. Vargas would be lectured by the court of, ma'am, we're not discussing child support today. We're discussing visitation today. So the court would limit that conversation to your pleadings, which is about visitation. Okay? Do you understand, Mr. Welch? Okay, so
Yes, sir.
today the pleadings are about child support. That's what they're about. That's why Mr. Morgan said that's not before the court today. He's correct. And I'm trying to explain to you what he means by that. It doesn't mean, well, nobody cares about you getting to see your kids. That's not what this means. It means that
No, clearly it's about money.
hold on,
and I can
hold
see
on. Let
it.
me finish, Mr. Welch. I'm not finished. Today it's about the child support. That's what they filed, and they want to know if you are agreeing, okay, about this child support.
I agree to supporting my children if I can see them.
Okay, but you see, when you make a statement like that, the problem is you're going against what I've just explained to you, that you cannot, Ms. Vargas cannot say you only get to see the kids if you pay me money. She doesn't get to do that. She does not get to do that.
What's to stop me from
And
going
hold
to
on,
watch-
and you don't get to say you do not. You only pay money if you get to see your kids. You can't do that. That's against what the law states. It's apples and oranges. Okay, now we can either, if you're in agreement with the child support part of this order, we can go forward and get this order entered and get the child support part of it dealt with. If you're not in agreement,
What do I need to sign? Just I'll sign. I agree with whatever.
okay, but I just didn't want you so frustrated that you thought nobody was protecting your rights. Okay, we just can't do visitation issues today, but you have a right to take
Let me
visitation issues to a judge.
in the child support modification order. It does talk about access and visitation. That is in
Right.
That is in the trust rental.
Those whatever those terms are still in place. We're just not modifying them today. Okay.
Okay.
All right then. So, Mr. Morgan, you want to continue with your questions? I think Mr. Welch. Now, I'm going to get to you, Miss Vargas. Don't worry, Mr. Morgan. Do you want to go through the questions with him as to what his agreement is? With
Yes, Judge.
child support?
Mr. Welch,
Yes, sir.
are you currently employed? You're muted right now, Mr. Welch.
Sorry. No, sir. I'm looking for work.
And you understood today that part of the order will be ordering you into the NCP Choices program,
Yes.
and that the NCP Choices program can help you find employment.
Yes, sir.
Sir, you understood that today we are going to be setting child and medical support at a minimum wage presumption,
Yes, sir.
and that we are giving you a credit for one child outside of the case.
Okay.
You understood that that was part of the calculation and calculating what you owe for.
I mean,
these
I don't see what my other child would have to do with them. She
It
did.
You
actually
understand
helps
that
you,
you get
Mr.
a
Welch.
credit against your child support for that other child.
Oh,
meaning
I didn't know that. So
deduction.
yes, sir.
Okay.
Yes.
You understand now?
Yes.
And you understand that the guideline child support in this case with one child outside of the case is $310,
Yes, sir.
and that the medical support will be $30.
Yes, sir.
That's all the questions I'll have of the witness, Judge. Besides that, you understand that this is going to be on a temporary order, sir.
Yes, sir.
That's all the questions I'll have. I'll pass the witness, Judge.
Okay, I have a couple questions actually for you, Mr. Morgan. This child support of $310 a month and cash medical $30 a month, is the start date going to be March 1st, 2026?
Yes, Judge.
Okay, per the temporary order. Okay. You also brought up a cash medical arrears of $730.08.
Oh, yes, Judge. If I could briefly recall, Mr. Welch, thank
Go
you.
ahead.
Yes, sir.
We could also reserve that for the final, but it's up to you if you want to reserve the judgment or not until then, I guess.
Well, was there going to be a child support arrears judgment as well?
There's going to be no child support arrears judgment, but I mean, we could just do the judgment in the final order if you want.
No, since you already talked to Mr. Welch about it, let's go ahead and put that on the record.
Okay. Yes, sir.
He's agreeing to that and when the monthly payment and when it'll start.
Yes, sir. All right, Mr. Welch, if I could, I'm going to recall you and ask for you to look at my screen once I get it ready for you. Are you able to see my screen right now, sir?
Yeah.
I'm trying to get this thing moved for us. Okay, there we go. And sir, you're able to see this sheet right here, which represents the pay record in your case.
Yes, sir.
And you see up here, it has your name and the other party's name.
Mm-hmm.
And so, sir, you understood that based on the last date of January 2026, that you were in medical support arrears in the amount of $730.08, according to the pay record.
Yes, sir.
And you understand that the state would take a judgment for that amount today. You understood that that's what's happening?
Yes, sir. I don't have to pay all today. I won't be able to make a payment until I get my check. So
Yes, sir. And you understood that the state would be requesting you to repay that at $50 a month?
yes, sir.
That is all the questions I'll have of this witness, Judge. I'll go ahead and pass the witness.
Okay. All right. Is there going to be court costs on this?
I believe I at least the way that I've done it before is that those were reserved for the final order, but if you want me to do that in this order, I can.
No, that's okay. We'll just hold off until final. Okay.
Yes,
All
Judge.
right. And we're not doing anything to change visitation this time. The current modification order is what's in place, right?
Correct, Judge. That's what the OAG filed was just to do
If I have a
support.
question about something on there, can I bring that to y'all's attention?
Well, hold on, Mr. Woods, I'm getting back to you. So
Yes, sir. Yes, sir.
Mr. Morgan's now done asking his questions for you, so I'm gonna ask you. All right. With regards to child support issues, okay, and you now understand visitations are different
Yes, sir.
in different setting, different court setting. With regards to child support issues, the terms have been read in the record. You are in agreement with those terms?
Yes, sir.
Okay, all right. And with regards to child support issues, do you have anything else you want to tell the court at this time?
No, sir.
Okay, with regards to child support issues, do you have any other witnesses you want to call at this time?
No, sir.
Okay, with regards to child support issues, do you have any questions for Ms. Vargas at this time?
No, sir.
Okay, is there a question you wanted to ask me or or a statement you wanted to make to me at this time?
Yes, sir. I just want to make sure, like, in that order, there's nothing that says I'm not allowed to see or be around my children, correct? I'm just trying to make sure I interpreted that right.
Well, what I'm saying to you is that the order that gives you visitation rights and whatever visitation rights you currently have, we're not changing that at all today. So that's to answer your question, to say, no, we're not doing anything.
Well, no, I'm not asking you. I'm just saying there's nothing on that order that says I'm not allowed to see or be around my children, correct?
This order that's being prepared by Mr. Morgan is going to deal strictly with child support.
Okay.
Isn't that correct, Mr. Morgan?
It is, Judge, and if I may ask the court to take judicial notice of the order on February 14th of 2025, which is what Mr. Welch is referring to. On that date, we did an order on motion for further remedy, which if we look at page 4 on that order on the possession and access, it states that the parties essentially agree that well, maybe not agree, but that was ordered. Possession is at the discretion of the other party, Ms. Vargas.
Which is bullshit.
Okay, so the possession and access is by agreement, right?
By agreement.
Okay, that's what that says. Okay. So yeah, to answer your question, Mr. Welch, that you brought up, by the way, I'm taking judicial notice of the file in that order.
I was incarcerated during that order, and they did not take me to go to that meeting, so I wasn't even present.
I understand. What I'm trying to explain to you is you asked a very good question. You said that what we're doing right now, is that going to change? Is that changing any of my prior visitation terms?
Yes,
And the
sir.
answer is no.
Okay.
And what Mr. Morgan's pointing out is he looked at the prior order that was done that says your visitation is whatever you and Mrs. Vargas can agree to.
Yes, sir.
Okay? So so you have a right. You do have a right. We're not dealing with the modification of visitation today. But
No, sir, I understand. I was just trying to get it
I want
clear.
to make sure, and nothing's being changed on that today. But
Yes, sir.
under the prior order, it's whatever y'all agree to. You have a right to hire private counsel, get an attorney, and come back to court and ask that as a hearing specifically about visitation terms. You do have
Okay.
that right. Okay?
Yes, sir. Thank you.
Okay. Is there anything else you need to tell me at this time?
No, sir.
Okay, Mr. Morgan, you may call your next witness.
Thank you, Judge. State calls Ignacia Vargas. Ms. Vargas, could you please state your name for the record?
Ignacia Vargas,
And ma'am, your relationship to the children in this case.
their mother.
And you heard me read into the record what I believe to be the agreements in this case. Did you hear those?
I did.
And did you agree to what I said as far as how we are setting support today?
I do.
And you understand that we use a minimum wage presumption because the other party is unemployed right now?
I do.
And that we're ordering him into the NCP Choices program.
Yes, sir.
And ma'am, you understood that minimum wage presumption with one child outside of the case was $310?
Yes, sir.
How were the children covered on health insurance?
They all have Medicaid or CHIPS.
And so you understood that the state's requesting $30 as cash medical reimbursement for that.
Yes, sir.
And that both of those payments would begin March 1st.
Correct.
And ma'am, you understood also that we took a judgment today for that medical support.
Yes.
And you understood that that medical support is owed to the state and not to you.
Correct.
And that we ordered a repayment on that, or $50 a month.
Correct.
Lastly, ma'am, again, because this is a temporary order, you understand that that means that we're going to be coming back to court.
Yes, sir.
And you understand that the court's going to give us a date for us to come back for that reset time.
Okay. Well,
yes.
will we be served with that, or should I expect something in the mail?
So the temporary order that we're gonna send out to everybody is gonna have the information as far as the reset date. Also, since I confirmed both an email address with both of you guys, y'all will both also get a hearing notice that'll be sent to you through our office in regards to that new date whenever we're gonna come back and finalize.
Perfect. Thank you.
All right, Judge. And ma'am, you understood that court costs are gonna be reserved for final hearing?
Yes, sir.
All right. I think that's all the questions I have, Judge, of this witness. I'll go ahead and pass this witness.
Are you wanting to get the pay record admitted into evidence?
Judge, yes, if I could admit that into evidence as a self-authenticating document, yes.
Okay. Is it an exhibit number or?
I'll attach it as Exhibit 1. Or rather, I guess I'll attach it as Exhibit 3, since we have, or wait, no, we've already established paternity. This is a modification. It's going to be Exhibit 1. Sorry, I was thinking about that last one with the 2 AOPs.
Okay. All right. Mr. Welch, you looked at that pay record that showed that you owed that $730. You're going to pay that back at $50 a month, right?
Yes, sir.
Okay. Do you have any objections to that pay record, which is marked as Exhibit 1, being admitted into evidence?
No, sir.
Okay. Ms. Vargas, do you have any objection to State's Exhibit 1 be admitted into evidence?
No, sir.
Okay. All right. Then State's Exhibit 1 is admitted into evidence.
Thank you, Judge.
To rule at this time, Mr. Morgan?
Well, if you're ready, I'm for sure ready for a ruling, yes.
Okay. What reset date are you looking at?
Whatever works best with the court. I hadn't had a chance to look for sure at what the next docket date was. I think maybe April 17th, it looks like, is the next one on Zoom.
Well, the reason I'm asking you is because aren't we waiting? We're doing temporary order so that Mr. Welch can
look at some employment.
Right.
Yes,
you
sir.
might want to give it a few months to get him to go work.
So then how about June 12th?
That's good. June 12th?
Am I available on that?
Yes.
Is that
That's a Zoom date.
Sister's birthday.
June 12th?
Birthday's yellow.
Okay. All right. Hang on a second.
Yes, sir.
Make sure that's not when I'm supposed to be up on the Frito. Okay. All right. Okay. All right, then we're going to set it for final orders for June 12th. Okay, let me ask you, Ms. Vargas.
Yes,
Real
sir.
quick. Do you have anything else you want to tell the court at this time?
No, sir.
Okay. Do you have any other witnesses you would like to call at this time?
No, sir.
Do you have any questions for Mr. Welch at this time?
No, sir.
Okay, then. All right, then I am ready to rule. I do find that I have jurisdiction of this case, and I do believe that the agreement y'all have reached is in the best interest of the children. I am granting the modification that's been requested. I'm ordering Mr. Welch to go to the Choices program, and so we're going to do this as a temporary order today. We are going to, however, continue, y'all. I assume y'all are joint managed conservators of the children. I'm going to continue that. I'm not going to change anything with regards to visitation at this time, or y'all's rights that y'all have. I am, however, going to set child support on a temporary basis where Mr. Welch will pay $310 a month, and that's based on a minimum wage standard, taking into account one other child. He'll pay $310 a month in child support to Ms. Vargas beginning March 1, 2026. Mr. Welch, because the children are on government insurance, will pay cash medical of $30 a month. That goes to the government beginning March 1st, 2026. There is no child support arrears. There is a cash medical arrears owed of $730.08 as of January 31st, 2026. That is owed by Mr. Welch to the state. That is to be paid back at $50 a month beginning March 1st, 2026. I'm ordering that this case will be reset for final on June 12th, 2026. And I'm rendering this order as of today. That means it is effective today's date. Okay.
Yes, sir.
But so we've had our full hearing. Everybody's under oath. Everybody got to testify, and so we've at least resolved that part of it on a temporary order on today's date. You want me to set this for entry in a week, Mr. Morgan?
Yes, Judge.
Okay, so we're going to set for entry in 1 week, which would be February 20th. Now, Mr. Welch, what that means, and Ms. Vargas, what that means, I'm about to let you guys go, so hang on.
Yes.
Is that Mr. Morgan's going to put this order together on this child support as a temporary order, including the provisions about the choices program and stuff. He's going to put all this together. He's going to send it to you, Mr. Welch, for you to review it and sign by DocuSign. And he's going to send it to you, Ms. Vargas, for you to review and sign by DocuSign. If I don't get it back from y'all by February 20th, I'm going to go ahead and sign the order with or without y'all's signatures. But this gives y'all a chance to look at it, make sure it does say what y'all agreed to on the record today in court. And if y'all have any objections, y'all can raise any objections to it, but it should accurately reflect what we did in court today.